We at Phlorum are experts on dealing with Japanese knotweed on commercial development sites. It was on this basis that we were founded in 2003. We have worked on a very wide range of commercial projects, construction schemes from very small sites up to very large sites for some prestigious house builders and other commercial clients. We worked on the 2012 London Olympics, and before that London Wembley Stadium, and a whole host of developments all across the country. Due to a number of landmark legal cases, it's becoming more and more important that developers recognise the issues associated with Japanese knotweed and take measures to identify it on their sites as early as possible, and then if they do find it, to remediate it effectively and appropriately. The principal piece of legislation dealing with Japanese knotweed growing across site boundaries is the Wildlife and Countryside Act. This was intended to protect wildlife, the countryside, ecology, biodiversity. However, it is very rarely used to prosecute people for allowing Japanese knotweed to spread across their site boundaries. Recently, in recognition of Japanese knotweed being a people and property issue rather than a wildlife and countryside issue, legislation was changed to allow antisocial behaviour orders or community protection notices to be issued against those who allow Japanese knotweed to spread from their land and affect others nearby. Civil litigation has become the principal means of redress in Japanese knotweed cases. A good example of this is the landmark ruling Wastel and Williams versus Network Rail Infrastructure, in which Phlorum provided the expert witness services. In this case, the claimant's properties abutted a railway line owned by Network Rail that contained a lot of Japanese knotweed. It had been there for more than 50 years. As a result, neither claimant could sell their property. The mortgage lenders identified the knotweed and wouldn't take on the risk. Network Rail failed to take the issue seriously, and subsequently the case was heard at trial. Unfortunately for Network Rail, judgment was handed down against them, they appealed the decision, and they failed on the appeal too. Importantly, although it was found that no structural damage to the properties had been caused by the Japanese knotweed, the court found that the mere fact that it had encroached onto the properties meant that Network Rail were liable to pay for the diminution in value of the properties caused by the presence of that knotweed. And this sets a very important precedent, meaning that anyone who has knotweed that encroaches onto a neighbouring property could be held liable for any diminution in value caused to that property.